Previously, we've had on Shay Hughes, an attorney who works as a public defender in the state of Indiana. He goes online by the name Hoosier Public Defender. We'll include his social media information in our show notes.
We really appreciated his insights and wanted to check back in with him now that there have been a few pre-trial developments in the case. In this episode, we spoke about the emergency motion, a few sealed subpoenas, and the air of secrecy around the case. My name is Anya Kane. I'm a journalist.
And I'm Kevin Greenlee. I'm an attorney.
We first connected while looking into the Burger Chef murders, an Indiana cold case. Together, we built a spreadsheet documenting hundreds of cases of restaurant-related homicides. That original spreadsheet gave way to our podcast, the Murdersheet.
Now we maintain that same research-centric, investigative approach as we look into all sorts of homicides, including unsolved cases, historical crimes, and, of course, restaurant murders.
We don't just chat about the headlines. Our podcast is a platform for our journalism. The Murdersheet focuses on investigative reporting, thoughtful analysis, thorough research, and in-depth interviews. We're the Murdersheet.
And this is the Delphi Murders, Emergency Motion, Subpoenas, and more with the Hoosier Public Defender. There's been a lot that's been going on in the case since the last time we spoke. What are some of the things that jump out to you?
I would say the first thing that jumps out to me is that the parties ultimately stipulated on the change of venue. I was somewhat surprised about that, just given the filing that they provided, and that I think there are some issues ultimately with conducting the trial itself within Carroll County. That would be the first thing. And then the other one would be more recent as far as the order goes for the safekeeping of Richard Allen. I'm not surprised that he's remaining in the Department of Correction, but I am surprised that no hearing was ultimately held or even scheduled in reference to that issue, because by statute, Richard Allen is required to have a hearing.
By statute regarding emergency filings like that?
Yeah, by statute, if he contests his placement, he's entitled to have a hearing on that issue. And I think just kind of the background, the fact that the judge that initially made that ruling, ultimately recused himself, that decision was made without an evidentiary hearing, without counsel. So I was surprised by that.
When it comes to that emergency filing, in your work as a public defender, do you see those sort of filings happen a lot, or is that an unusual move by the defense?
Belated filings, or emergency filings, they happen all the time, but this type of filing, you don't see often. I'm guessing that's why a hearing wasn't held, is it's just something that the judge may not have experience with or have even dealt with previously. But for what it's worth, Richard Allen's attorney did ask for a hearing if the court was not inclined to grant the motion itself.
Was it unusual that it took, I think, about a week for a response, and in addition to not actually having a hearing?
It's not unusual for there to be a response filed by the state approximately a week afterwards. The order itself, it came out around 9 or so days after the motion was filed, which I would say is pretty typical. So I don't think there's anything too unusual about that.
And then one thing we noticed that we thought was a little bit odd, but maybe a bit in the weeds for our audience, is that initially the filing seemed to be available on My Case. We know a number of media personnel downloaded it, and then it sort of went offline and the file was no longer available on My Case. And we thought that was a bit unusual, and it's not really clear why that happened. Some people have speculated that there could have been a outage that caused that, but does that strike you as odd that it was sort of available and then seemingly possibly removed?
Yeah, I'm not sure what went into that. I wasn't even aware that it was previously available for a little bit of time. But, I could tell you when you file these, you generally have to have essentially a cover sheet under administrative or under the access to court records rules that spell out if you're going to file something confidential. That's required. And then you have to provide essentially the applicable rule along with any statutes that you're relying on for why the filing should be confidential. Then when you actually file something electronically, it'll ask you, is this a public or a confidential filing? And then you just preface which one it is, and then ultimately you submit it. In this case, the motion itself, I don't recall there being any type of cover sheet that simply stated that this should be a confidential filing. So I'm somewhat perplexed, I guess, why it was marked confidential then.
Yeah, it struck us as odd, as you said, given that there didn't seem to be any indication from the defense that it was confidential, and it is a public filing, in this case. I guess one thing that has sort of been interesting to us is some of the details contained in the emergency filing therein, sort of about Richard Allen's conditions in prison and some of the discussion around that. And just as somebody who works in the criminal justice system in Indiana, how did that strike you? Was anything surprising, or did certain things seem like things that you have seen before in your work?
I wouldn't say anything's pretty surprising. I was kind of shocked just to see the photo itself and the shape that Richard Allen was in. But nothing surprising. I've never been to Westville. I can't really speak to the facility itself. All I can say is, from my clients and from what I've read, it just doesn't have the best reputation. But that's not to say that there is, some type of resort prison out there that people speak highly of either. I think that just kind of comes with these types of facilities. But there's nothing shocking. I hear that a lot, that people say that their physical and mental health needs aren't being met within the DOC.
What about the whole issue of him being kept in a prison before he's even been convicted? Is that something that's unusual in Indiana?
Well, it is unusual. I could tell you, I've worked thousands of cases, and I have yet to have a client that had to be removed from the local county jail and placed in the Department of Correction or another facility within the county. I can only think of one other case that I've come across where I've seen it happen to somebody else, and I can't even really recall what transpired in reference to that case. So it is pretty unusual for that to happen.
When it comes to the element of Richard Allen's mental health, mental wellness, which sort of Attorney Brad Rosie is sort of calling into question here in this filing, I suppose, what are your thoughts on that as far as the mental health of a client whose trial is pending? How important is that for, what is to proceed? Our understanding is that if he's declared not competent to stand trial, that will result in delays and, it'll certainly be a problem. But I guess, what are your thoughts on that topic?
Well, I would expect that, even though that Richard Allen may be in some type of physical or mental decline, that he still understands the proceedings. He still understands, the charges against him. He understands the role of counsel, the role of prosecutor, and so forth. So I'd be shocked if there is any type of competency issue that would come up. But look, it's better to deal with a client that is sharp, that is mentally all there. Because ultimately this trial, I think, to me, is going to depend on Richard Allen. from what the state has provided, or at least from what we know from the probable cause affidavit, he puts himself on the scene. And, he's going to have to recall events that transpired and provide, if he's going to testify, specific details that are 5, 6, and probably even more by the time this goes to trial years ago. And that's difficult. So it's better to have your client in a good physical and mental state than a poor one. Yes.
Can you explain to our listeners what is the process to determine whether or not someone meets the benchmarks to be competent to stand trial mentally?
Well, I would say it's pretty low. Essentially understanding the proceedings, understanding the nature of the charges against them, understanding the role of the attorneys, understanding the role of the judge. And there's a lot of clients that meet that threshold. And I'm not aware of him having any prior mental health issues.
And then when it comes to, I suppose, what we're seeing as far as the prosecution's response to this, it seems like the judge responded by essentially indicating that he could be transferred within the DOC, but didn't really see a big pushback from the prosecutor. And is that unusual to you, or would you maybe expect that?
I really don't know what to think of it ultimately. For what it's worth, they obviously didn't file the initial motion itself. It came directly from the sheriff's office. So I don't really know what to make of it. I thought, if I recall correctly, that Alan had stated in his motion something to the effect of that the prosecutor didn't mind if it was cast or if he was moved.
That's right.
I don't think it really matters too much to them.
In terms of one thing that has happened since that I thought was interesting is we've sort of seen a flurry of subpoenas. Is that right, Kevin? For Richard Allen. And they're all sealed at this point. But, if you could maybe talk a bit just for our audience that might not be so familiar with the legal system about the role of those and obviously we're not going to speculate about what those could be because it could be anything, but as far as like pretrial subpoenas, what can we kind of tend to see with that?
Well, there's really not too much to take out of it other than, essentially it appears that the state is trying to obtain some type of additional discovery, some type of evidence from a third party that is not an agent of the state or of defense. And other than that, there's really not much that we can read into that.
Is it typical for them to be kept secret, these subpoenas?
I haven't seen it done like that. It just depends on the information you're seeking and if there is some type of confidentiality statute that would apply. In that respect, it's not something that typically I've seen done, but, I get it depending depending on the information that you're seeking, that you would ultimately, if there is confidential information that's within the subpoena, then yes, you would have to mark it confidential.
One thing we've noted, and I think, this is certainly an opinion on our parts, but I think it's supported by the facts. You have a gag order set up by the prosecutor. You have a situation where Nick McClellan, the prosecutor in this case, seemed very reluctant to release the PCA, was fighting that. And then, even now you're having kind of these sealed subpoenas and whatnot, and very, very well, maybe very good reason for that. But there does seem to be a bit of a pall of secrecy over this case as far as how the prosecutor is handling it. Do you agree with that assessment? And I guess, what do you make of that?
Well, I would agree with that. If you go back to February, the public access counselor, released an opinion that was very critical of Indiana State Police and found that Indiana State Police violated Indiana law when they failed to timely provide a daily log and record to the Journal and Courier. And, what I thought was kind of telling in that opinion from the public access counselor is that ISP essentially cited to the prosecutor and to Judge Diener as factors in their delay for not providing the daily log or record to the media. And what I did find interesting is at the end of that opinion, the public access counselor noted that those matters are going to be addressed in other opinions. Now, when they come out, I don't know. But, it seemed like ISP was passing the blame onto somebody else. And the access counselor reminded them that, no, those are law enforcement records. They have nothing to do with the judiciary and that they should have been provided in a timely manner. So I guess we'll see what comes out of the access counselor's opinions as it pertains to both the judge and the prosecutor.
Absolutely. And it's interesting because it definitely is law enforcement's purview that they were talking about in that instance. But if they're telling the truth and that kind of mode of secrecy is being sort of handed down from the prosecutor in this case, it definitely is interesting because it's just, I think people who maybe are only following the Delphi case and are not familiar with maybe how other matters seem to work may get the idea that a lot of this is normal or how things typically play out. But I think a lot of the things we've noticed seem pretty unusual.
Yeah, no, it's not typically how it plays out. I mean, generally, someone gets arrested, they get booked in, they have an initial hearing scheduled, probable cause affidavit, the charging information are generally made public, and they have an initial hearing scheduled that is public to everybody, and that's kind of that, and at that initial hearing, the charges are provided to the defendant. You find out what's going on with counsel and so forth, and you set trial dates. This one kind of went by pretty quick, the timeline. That was pretty unusual. And the other thing that I would know, as well, is him being, immediately transported to White County. That doesn't happen often where somebody gets immediately removed to a different county right after their initial hearing. And I think there is something to raise about, I guess the legality of that, because again, it wasn't like they waited for move the court and then received an order to do so. That move occurred, and then afterward they filed a motion asking that he be removed and placed in the DOC. So yeah, the initial procedure in reference to this case is unusual.
And let me ask a very basic softball question here. Why is it so important for all of that information to be made available to the public? The booking information, the what have you.
I mean, it kind of just goes to the integrity of the justice system, right? I mean, we should be made aware of it so we can evaluate it ourselves. There shouldn't be this different treatment just because of the nature of the case itself. The public has a vested interest in its judicial system and should know what's going on with law enforcement, with the judge, and so forth. I mean, you can imagine, right? I mean, if things were kept private, if you were kept in the dark, I mean, what would ultimately transpire, right? I mean, it'd be difficult to hold folks accountable. We would probably see injustice going on, people receiving different sentences and so forth, and no one ultimately being held accountable if everything was left confidential or private.
Yeah, it definitely seems like this case is eliciting some unusual moves from the prosecutor here that kind of go counter to a lot of that. But, it'll be interesting to see how it develops.
Yeah, it certainly will. To get back for a moment to the subpoenas. The subpoenas that were filed with the court were the ones that not the type that require a person to come forward himself, but the type that requires a person to produce documents. Can you talk a little bit about that and what that sort of thing means and what documents people may be looking for?
Yeah, I mean, basically you have two types of subpoenas. One is essentially for a person to appear at a certain time and date at a certain location, and then the other one is to produce some type of documents or evidence as well. There's really not much that I can add other than that. I mean, the subpoenas for any type of documents or tangible evidence or electronic evidence, whatever it may be, the possibilities are endless. I just simply don't know, what it would be for. All I can add is that, if you're subpoenaing some type of information, it's because, there's somebody that is not an agent of either party that has access to that information. And that's why you ultimately have to get a subpoena, which essentially amounts to a court order, right? I think that's an easier way to look at it, to hand over that document.
You may not be able to answer this, but I guess with the subpoenas happening now, would that indicate that they're in relation to something that prosecution or law enforcement only recently found out about, and that it's essentially could be a new development in the case that they're reacting to? Or is it a situation where it very well could have been in the works for longer, I guess?
It could be either or. It really could be either or. And all I would say to your listeners, is that I would just stress that it's just not fair to speculate what the subpoena is, because it could be anything. It really could be.
Right.
Another question we get a lot is this bond hearing is now scheduled for June, which will be close to 8 months after Richard Allen was arrested. Is that delay unusual?
It's not necessarily unusual. I personally hold off on, just generally speaking, right? I mean, on a typical case for bond reduction, because I know immediately on a typical case, the court's going to say, look, I just made a finding of bond, a week or 2 weeks ago. How many times have we dealt with this where your client ultimately is able to post it, after the motion to reduce the bond is denied? So I think there needs to be some type of, on a typical case, some type of showing that they cannot afford the bond, right? Going in the following day really isn't going to prove that. Now, this case is different, right? I mean, he's held no bond. With it being set 8 months out, no, I don't think there's anything unusual about that. I would venture to guess that most bond reduction hearings take place, it depends on the severity of the case and the nature of it, probably a handful of months after the initial hearing. But it's different on a murder case, right? Because he's held no bond, and it's important, this type of hearing, because essentially the court is going to be deciding or essentially commenting on the strength of the state's case by deciding whether or not to continue to hold Richard Allen with or without bond. So that makes it extremely important, especially in this type of case, because, from the public's perception, the court is essentially commenting on the strength of the state's case, and that's something that both sides have a vested interest in. So from defense, obviously, they want, at the very least, I don't think it really matters necessarily that he can even post a bond, but that he just no longer be held no bond, right? Because then it signals to the public, this case might be a little weaker than we initially thought. And from the state side, it's the exact opposite, right? They want to have him continue to be held no bond because it signals that they do have a strong case. So setting it out that long, because it is such a pivotal hearing, you want to adequately prepare. You want to have reviewed all the discovery so you can, I guess, put your best performance as an attorney in terms of examination and argument during that hearing.
A lot of people, of course, have commented that in the PCA, the state doesn't have to make as strong of a case as possible. They don't have to reveal all their cards. From your experiences in the bond hearing, is there a greater motivation there for the state rather to reveal more about what they have against the defendant?
Yes. The biggest reason is when it comes to this type of hearing, they just simply cannot rely. They actually have to present evidence that they would rely on trial. That's what's required of them, and they cannot just rely on statements made by the prosecutor as to what the proof will be at trial. They can't rely on the charging information or probable cause affidavit. They actually have to put on evidence for this type of bond hearing. So it is extremely important for the state.
this is perhaps maybe a bit out of the realm of the courthouse, but it's something we've sort of noticed as a phenomenon in this case. And since you practice law sort of in this general area, I guess we were curious to get your thoughts on it. And it's basically that, there's a phenomenon in the Delphi case where if anything seems to go happen in Carroll County or Delphi, or there's an arrest or a raid on a house, people sort of online start jumping to the conclusion that it's linked to the Delphi murders. And I wonder, just given that you practice law not too far away from that, if you could speak to the fact that this is an area with crime that is completely unrelated to anything we're seeing here, in that, it's, I guess, like the ecosystem of crime and criminality isn't totally concentrated on this one case.
Right. Yeah, there could be a number of things going on that are completely unrelated. And the reality is, if you look at it from a probability perspective, the probability is that it is not. And again, I would just stress, it is not fair to anyone to speculate about anything else. The only thing that you can go off of is what's publicly available. That's it. Nothing more.
And as you mentioned, if you're dealing then with a raid that has nothing to do with Delphi, but suddenly you're dragging people's names into it, into a murder of, double homicide of 2 children, then it's not terribly fair, especially if it's about something else, a drug bust or something.
Right. Right. Yeah. And I could tell you, speaking from experience, I represented James Chadwell here locally. He was initially thought to be involved with this, and I saw all the, all the comments on Facebook and on Twitter and people making their videos and so forth. And, that ended up not being the case, right? He had nothing to do with Delphi, and it's just not fair to other folks. It's not fair to the family of Abby and Libby. And it's not fair to Richard Allen. It's not fair to anybody to speculate.
No, and I think it just kind of goes towards people having a hard time believing that, multiple bad things can happen in an area, but that's the case.
Right.
Things can happen, and just because they're in the same area does not mean they're connected. And yeah.
Right. Look, all I can say, and I often tell this to clients and their families, conspiracies exist for those that can't accept the truth, right? And you should not speculate.
Yeah. We definitely try on this show to bring a dose of reality about the legal system and certainly what's going on here, but it's definitely difficult when there can be a real impulse to do that. And I think we understand it to a degree, but we don't think it's helpful in this case at this point, especially when there has been an arrest made with Richard Allen, and maybe the focus should be on what's going on with that case as opposed to, any other random thing that happens in Carroll County in the coming months.
Yeah, no, well said. I completely agree and share the same sentiment.
Yeah, thanks for dealing with me on my soapbox. I'm like, it's so crazy every time something blows up, and it's just, you're like, this is very, very unlikely to be related, but here we go again.
Right.
Listen, is there anything we didn't ask you about as far as recent developments in the Delphi case, or just understandings of the law in general that you wanted to mention?
No, there's really nothing I can say about the case itself. I guess just in terms of my expectations for the bond hearing, obviously the state's going to put on evidence. It's scheduled for 2 days. Whether or not they'll exhaust both days is anyone's guess. But what I would look for during the hearing itself is simply the state trying to narrow that timeline, and that they attempted to corroborate any timeline that Richard Allen provided. And from the defense side, I would, expect defense to kind of broaden that timeline, that they weren't able to narrow down and pinpoint Allen's whereabouts. In terms of evidence itself, I would expect the state is going to put on, a handful of witnesses. I mean, I would, on a case like this, they're probably going to limit the number of witnesses that they do call, and I expect them to put maybe on a couple of lead investigators that will summarily discuss the case. From defense, 99 times out of 100, on most bond hearings, you generally just call your client to testify, but it's generally about the relationship to the community, that they'll appear, that they have employment, so forth. But on a case like this, don't be surprised if they don't put on any evidence. So that's all I can add, is just kind of the expectations for the bond hearing. But with that said, they very well may call somebody. If they're going to call any witnesses, they may call lay witnesses that were on the trail that day to maybe discredit, what they said to police and so forth.
Absolutely. Yeah, that's definitely something that we're all looking forward to and hoping to get, just more of an indication of where this case is going and, the sort of the shape of the case against Richard Allen. But we really appreciate you coming on, Shay, and talking to us. Yeah, thank you so much.
Yeah, no problem. Thank you for having me.
Thanks to Shay for sharing his insights and time with us.
Follow the Hoosier Public Defender on Twitter at @publicdefender_, or follow him on Instagram at Hoosier Public Defender.
Thanks so much for listening to The Murder Sheet. If you have a tip concerning one of the cases we cover, please email us at murdersheet@gmail.com. If you have actionable information about an unsolved crime, please report it to the appropriate authorities.
If you're interested in joining our Patreon, that's available at www.patreon.com/murdersheet. If you want to tip us a bit of money for records requests, you can do so at www.buymeacoffee.com/murdersheet. We very much appreciate any support.
Special thanks to Kevin Tyler Greenlee, who composed the music for The Murder Sheet, and who you can find on the web at kevintg.com.
If you're looking to talk with other listeners about a case we've covered, you can join the Murder Sheet discussion group on Facebook. We mostly focus our time on research and reporting, so we're not on social media much. We do try to check our email account, but we ask for patience as we often receive a lot of messages. Thanks again for listening.